I am Vipul Puri, Deputy Director with Competition Commission of India. Today we are going to discuss the provisions relating to regulation of combinations in US and EU. The views expressed in this presentation are my personal views and do not reflect the views of either the Commission or any of its members. So far, we have discussed the basics of mergers and acquisitions. We have discussed substantive provisions of Competition Act 2002 for regulation of combinations and the various factors which are relevant in competition assessment. But as we all know that Indian competition law is in its initial stages. In fact, the provisions relating to agreements and abuse of dominance have been notified in 2009 and the provisions relating to regulation of combinations have been notified in 2011. Under such circumstances, it would be good to discuss the provisions relating to regulation of combinations in more evolved jurisdictions such as United States and European Union. The module focuses on the procedural aspects and the assessment methodologies of combination transactions followed in United States and European Union. After the completion of this unit, the participants are expected to understand the procedural aspects of regulating combinations in US and EU and the similarities and dissimilarities in the legal procedures followed in US, EU and India. Let us begin our discussions on US merger control by focusing on evolution of legislative framework. The oldest legal instrument related to antitrust is the Sherman Act, which was passed in 1890. It is important to note that the word combinations is mentioned in section 1 and 2 of the Sherman Act. The relevant sections read that every person who shall monopolize or attempt to monopolize or combine or conspire to monopolize any part of trade or commerce shall be deemed guilty of felony. The other section reads that every contract, combination in form of trust or otherwise or conspiracy in restraint of trade or commerce is declared illegal. Thus, we can notice that the relevant sections refer to the combinations in restraint of trade as illegal and combinations which are intended to monopolize any part of trade or commerce are called as a felony. However, the provisions of Sherman Act were broad based and a need was felt to introduce a law that provides further clarification and substance. For this purpose, Clayton Act was passed in 1914. The next major development in US merger regulation was passing of the Hart-Scott-Rodino Antitrust Improvement Act 1976, which is normally called as the HSR Act. The Act focused on increasing the powers of the competition law agencies and to prescribe the procedures which are required to be followed. This Act amended the Clayton Act by requiring companies to file pre-merger notifications with the Federal Trade Commission and the Antitrust Division of the Justice Department. The Act further establishes waiting periods that must elapse before certain acquisitions or tender offers may be consummated and authorizes the enforcement agencies to stay those periods until the companies provide certain additional information about the proposed transaction. After the development of jurisprudence on the issues involved and with significant experience on procedural aspects, the next logical step for any regulator is to come up with some guidelines on the important aspects of regulation. The next step in US merger control may be said as issuance of horizontal merger guidelines. The aim of horizontal merger guidelines is to standardize the analytical framework relating to mergers and acquisitions. These guidelines describe the principal analytical techniques and the main types of evidence on which agencies usually rely to predict whether a horizontal merger may substantially lessen competition. Further, the guidelines also lay down the principles for the relevant market definition, ascertainment of degree of concentration, the unilateral and coordinated effects framework, and peculiar issues of failing firm and merger efficiencies. The first step in US pre-filing regulatory procedure begins with when the parties have to check whether the transaction meets the thresholds for filing a pre-merger notice. In US, the thresholds are based on two criteria. The first is the size of transaction test and the second is the size of person test. Under a size of transaction test, if the transaction is valued at more than US dollar 303.5 million, the notification is required without any regard to the size of person test. However, if the transaction size exceeds 75.9 million US dollars, the transaction may be reportable subject to meeting of the size of person test thresholds. The size of person test thresholds presently are met if either the acquiring or the acquired person has at least US dollar 15.2 million in assets or sales and the other person has at least US dollar 151.7 million in assets or sales. In no case, however, a transaction below US dollar 75.9 million is to be filed. However, in some instances, a transaction may not be reportable even if the size of person and the size of transaction tests have been satisfied. The Act and the rules set forth a number of exemptions describing particular transactions or classes of transactions that need not be reported despite meeting the threshold criteria. Let us discuss the notifiability requirements again. If the transaction size does not exceed 75.9 million US dollar, the transaction is regarded as small and it is exempt. If the transaction size exceeds 303.4 million US dollars, the transaction is considered as large and it has to be filed. If the transaction is medium, that is, it is in the range of 75 million US dollars and 303 million US dollars, then it is to be filed only if the size of person test is also met. And the size of person test states that one person's assets and sales have to be more than 151.7 million US dollars and the other person's assets or sales have to exceed 15.2 million US dollars. Thus, it may also be said that the size of person test is applied only to find out the notifiability of medium transactions. There is complete certainty on the transactions which are regarded as small and the transactions which are considered as large. Now, what we can understand from the notification provision is that there are some similarities in the parameters based on which notifiability of a merger transaction is determined with the provisions in India. The thresholds in terms of values of assets and sale and some categories being exempted under the acts or rules. The differences lie in considering size of transaction, whereas in Indian Competition Act, we primarily consider thresholds on the lines of size of person test. After discussing the notification requirements, let us come to the form of notification. The US guidelines also prescribe a particular form which has to be filed for notification of a transaction. On the aspect of fee, the amount of fee to be paid for filing of combination notice in United States follows the slab system just like India, with one difference. In India, the fees depends upon the form of filing, that is whether you are filing in form 1 or form 2. In US, the slab is on the basis of size of the transaction. Now, let us discuss the US regulatory procedures, that is the procedures which are required to be followed after filing of the notification. Mandatory wait period. Once the filing is complete, the parties must wait 30 days or until the agencies grant early termination of the waiting period before they can consummate the deal. After receipt of notice, the next stage, which is very peculiar to United States, is the clearance process. The United States is a peculiar case as there are two agencies looking after the enforcement of merger control laws, namely the United States Federal Trade Commission and the Department of Justice. The parties file notification with both FTC and DOJ, and thereafter the staff at FTC and DOJ consult and the matter is cleared to be looked into one of the two agencies. Thereafter, the preliminary review of the merger filing starts. If the agency is of the opinion that the transaction does not have any adverse effect, it may simply allow the mandatory wait period to expire, or it may even terminate the waiting period, which is called as granting early termination. On the other hand, if the agency is of the opinion that transaction may have some adverse effect, the assessment reaches the stage of second request. It implies that the agency may seek comprehensive information from the parties to the transaction. It also empowers the agency to interact with the company personnel or the industry experts. After the stage of second request, a final decision has to be taken by the agency, and though that final decision can be closure, it can be modification, it can be remedies, or it can be a preliminary injunction. After the investigations are over, the agency may decide to close the investigation, or it may propose modification to the transactions or impose other remedies as it may deem fit through a consent agreement. In case of a deadlock between the parties and the agency, that is, when the consent agreement cannot be reached, the agency may file a preliminary injunction in a federal court seeking to stop the entire transaction. Now, after having discussed the US regulatory framework, let us compare it with India. The combination regulatory framework followed in US has both similarities and dissimilarities to the framework followed in India. Both the regimes prescribe thresholds for identifying the notifiable combinations and adjust these periodically. The mandatory waiting period in US is 30 days, and that is the time available to the agency for a preliminary review. The preliminary review, which is similar to the prima facie view in India. The Commission by Regulation 19 has also prescribed a period of 30 days for forming a prima facie opinion. However, some procedures are very different in US. If the Commission is of the prima facie opinion that the transaction does not cause any adverse effect on competition, in India we issue an order approving the transaction. However, in US the agency may just allow the mandatory wait period to expire, or it may grant early termination. The other major difference lies in final decision process in the case. If the agency in United States determines that the merger may be cleared with some remedies, it may try to get into a consent agreement with the parties. However, if the consent agreement is not reached, or the agency determines that the transaction is to be stopped, it has to approach the federal court seeking a preliminary injunction. In India, the Act empowers the Commission to issue final orders with modification, and if the modification is not agreed to by the parties, to issue final orders blocking the transaction. After these discussions on United States, let us move to discuss the provision relating to regulation of combinations as followed in European Union. Let us first discuss the legislative framework and what constitutes notifiable combinations in European competition law. The main sources of law for merger decisions in European Union are EC merger regulation, the implementing regulation, and the notices and guidelines. Let us understand what do these stand for. The merger regulation contains the main rules for assessment of concentrations. This is the term which is used in European Union for the combinations. The implementing regulation concerns procedural issues, that is notification, deadlines, right to be heard, etc. Notices and guidelines are relevant for proper interpretation of the merger regulation. Now, there is something very unique about European Union also. This is a case of community dimension. As we know that European Union is an economic and political union of member states located in Europe. The first question that arises here is whether a combination transaction would be looked into by the member state under their national competition law or the European Commission, that is the executive body of European Union. The answer depends upon whether a transaction has a community dimension or not. That is, whether a combination may affect a number of EU member states. The EC uses variety of parameters to ascertain whether a combination has a community dimension, such as it uses the worldwide turnover of the parties to the combination or the community-wide turnover criteria, and it also considers the breakup of community-wide turnover among the member states. Once it is determined that a transaction has a community dimension, it has to be filed with the European Commission. Let us understand the various tests involved in determining whether a transaction has community dimension or not, again through a flowchart. There are two tests and three stages in determination of community dimension of a combination. The first stage is ascertaining significance of a transaction considering worldwide turnover of the parties. The second stage is ascertaining significance of a transaction considering EU-wide turnover of the parties. And the third step is to check whether a transaction is likely to affect entire European Union or its effect may be restricted to a particular member state. Now, let us have a look at the flowchart. In the first test, we would ask ourselves a question: is the combined worldwide turnover of all undertakings concerned more than 5,000 million euros? If this test is fulfilled, we know that the worldwide significance test is met, and we move on to the next step where we would check the EU effect. We will ask ourselves a question: is the EU turnover of each of at least two undertakings concerned more than 250 million euros? If the answer is again yes, we know that the test qualifies for significance for EU also. Thereafter, one test is remaining, that is to find out whether the transaction impacts the entire European Union or whether its effects are restricted to a particular member state. This can be analyzed by asking ourselves a different question: that does each of the undertakings concerned achieve more than 2/3 of its EU turnover within one and the same member state? If the answer is yes, then EU merger regulation will not apply and it may be notifiable to that national competition agency. However, if the answer is no, then the EU merger regulation shall apply as all the conditions of this test have been fulfilled. There is an alternative test which says that if the combined worldwide turnover of all undertakings concerned is more than 2,500 million euros, it may still qualify to be notified to European Commission if the other conditions are fulfilled. And what are those other conditions? The other conditions are: number one, is the EU turnover of each of at least two undertakings concerned more than 100 million euros? If the answer is yes, further check: in each of at least three member states, is the combined national turnover of all undertakings concerned more than 100 million euros? If yes, again check: in each of at least three of these member states, is the turnover of each of at least two undertakings more than 25 million euros? If the answer is yes, then we would check the impact condition, that is whether the combination has an effect in the entire European Union or its effect is restricted to a member state. That will be checked with the 2/3 turnover criterion as discussed before. And again, if it is found that the turnover is generated within a particular member state, that is more than 2/3 turnover is generated within a member state, then EC regulation will not apply. Otherwise, EC regulation shall be applicable. Thus, on the basis of these discussions, we can note that European Union uses a variety of criteria to ascertain whether a transaction is required to be notified to European Commission or to the National Competition Agency of any member state. Now, let us go into the regulatory process followed in European Union. The first stage is receipt of notification. The parties to the transaction are required to notify the transaction if it has the community dimension. The notification is required to be made either following the conclusion of an agreement in that respect, or announcement of a public bid, or following the acquisition of control, or after manifestation of good faith intent on part of both the parties to enter into a transaction. After notification has been filed, the initial examination, or what is called as phase 1, would start. The EC would undertake detailed examination of the transaction based on the information submitted by the parties at the time of notification, additional information sought from the parties, interviews, etc. The Commission has a time period of 25 working days for reaching the decision. What can be the outcomes of phase 1? At this stage, the Commission may decide that the concentration does not fall within the scope of merger regulation, or the Commission may approve the concentration if it does not raise any doubts on adverse effects, or it may decide to further investigate the transaction, that is, launch what is called as phase 2 investigation. It is also possible that the parties may approach the Commission with commitments, and in that case, the period of 25 days may be extended to 35 days. Now, let us go through the procedure which is required to be followed if the European Commission case goes to phase 2. The investigation under phase 2 is more comprehensive, and the Commission may ask for more information, carry out further interviews and inspections, etc. The Commission has to issue statement of objections and give a chance to the parties to access the files and request for oral hearing. The available time for phase 2 investigations and decision is 90 working days commencing from the date of decision of going into phase 2. The period may be further extended to 105 working days in case the parties offered commitments after 55 working days from the date of initiation of proceedings. A further extension of 20 days is also permissible by way of reaching an agreement with the parties. After the detailed investigations into the impact of a concentration on the competition process, the European Commission has the powers to take decisions approving the transactions without any condition or conditions, approving the transaction with conditions and obligations, or completely stopping the transaction. Now, let us discuss the similarities and dissimilarities between the procedures followed in EU and India. One feature of EU regulations that makes it completely distinct from any other jurisdiction is the community dimension. Other than the community dimension, it is observed that the EC also follows thresholds approach, but again it is unique of EC to consider the turnover for thresholds and not the size of the transaction or the value of assets. The Indian Competition Act 2002 considers both the turnover and the value of asset thresholds and conclude notification requirement on basis of either of those. The phase 1 stage of merger assessment is similar to the prima facie view stage followed in India. The other similarity is in the order framework. The EC also issues the order clearing with or without conditions or blocking the mergers, and the decision is subject to appeal, as is the case in India. This completes our discussion on regulation of combination framework followed in US and EU. Thank you.